Hey, how you doing? This is Adam Post, publisher of more than 1,000 comic books and marketing expert covering woke CEO who fires man for being too white gets massive lawsuit. Let's get into the story. Before we do, please be sure you are subscribed to the channel. Click the bell for notifications. Give me a thumbs up. I really appreciate you guys. How white is too white? Well, we're about to find out. From the Daily Caller, man sues IBM company after they allegedly fired him for being too white. And from Bloomberg, IBM's Red Hat sued by Stephen Miller's legal group for anti-white male bias. Again, Stephen Miller's America First legal group is heroic. They take on another challenge. Originally, America First Legal filed an EEOC complaint. This goes back to December 2023. America First Legal slams IBM for racially discriminating against white and Asian Americans, files federal civil rights complaint. And since the EEOC has said they're not going to be following up on this and they're going to dismiss the charge of discrimination, it creates a 90-day window that the plaintiff can sue. And he is suing. He's suing Red Hat for discrimination. And this is being done in partnership with Robert Barnes, who is co-counsel with America First Legal. Rather than discuss this through an article, we're going to go through the actual legal filing today. This is Allan Kingsley Wood suing Red Hat, a North Carolina corporation and subsidiary of IBM. In the United States District Court for the District of Idaho, plaintiff Allan Kingsley Wood was a loyal, dedicated, and skilled employee of 8 years who performed the role of senior director for defendant Red Hat Incorporated. Though he was an exemplary employee and on a fast track to becoming an executive, plaintiff became a victim of Red Hat's discriminatory employment policies and was punished for criticizing the same. The newest corporate trend is implementing what's referred to as diversity, equity, and inclusion, DEI policies. Ironically, these policies promote discrimination in the name of anti-discrimination, punish certain ethnicities in the name of diversity, and reward skin color over merit. Corporations aim for certain quotas in terms of ethnicity and gender in their workforce, which inherently necessitates prioritizing skin color and race as primary hiring factors. In essence, Red Hat is using diversity as a license to discriminate. In violation of multiple federal and state laws, Red Hat engaged in discrimination against the plaintiff on the basis of race, color, religion, and sex. On to the facts and the background. Plaintiff began his employment with Red Hat in 2015. He held the position of senior director for several years and worked at Red Hat's location in Singapore. In 2021, in response to stringent COVID-19 policies in Singapore, Mr. Wood requested to be transferred to a position in the U.S. Red Hat approved the transfer on September 23, 2021, and coordinated with Mr. Wood to move to the United States. Upon his arrival in the U.S., Mr. Wood was required to work from home due to his refusal to take a COVID-19 vaccine. Mr. Wood had sought an exemption and accommodation on religious grounds. His exemption was approved, and as an accommodation, Red Hat imposed the restriction that Mr. Wood was required to work from home. Upon returning to the United States, Mr. Wood conducted his work from home in Idaho and began his U.S.-based role on October 1, 2021 as Senior Director of the North American Office of Technology, Technical Sales, West Region, North America. Mr. Wood was an exemplary employee. He had never received a negative review, was highly lauded, had a stellar record, and was on a path to become one of the top executives at Red Hat. Plaintiff received overwhelmingly positive performance evaluations. But the defendant, Red Hat, had DEI policies, and those policies took precedence. Beginning in 2021, Red Hat began implementing a number of discriminatory policies and goals centered around diversity, equity, and inclusion initiatives in the workplace. In accordance with this effort, Red Hat hired Suchi Sharma to act as the Chief Executive Officer of DEI to spearhead these programs, which included holding mandatory trainings and implementing policies aimed at achieving diversity goals. Indeed, Red Hat has made it clear that it is in favor of discriminatory policies that the Supreme Court has found unconstitutional. In the case study of Students for Fair Admissions versus Harvard, decided together with the SFFA versus University of North Carolina, Red Hat, along with 70 other corporations, filed an amicus brief with the U.S. Supreme Court in support of affirmative action. In an August 2nd, 2022 email, Red Hat boasted of the company's involvement in this effort to its employees, claiming that Red Hat was, quote, proud to join this effort to ask the U.S. Supreme Court to continue to allow colleagues to consider race as one of many factors in admissions so that colleges can produce a diverse pipeline of graduates. In a historic decision, the U.S. Supreme Court struck down affirmative action in June 2023. The Supreme Court ruled that the affirmative action admissions programs used by the University of North Carolina and Harvard College violated the Constitution's Equal Protection Clause, which bars racial discrimination. However, Red Hat's promotion of unconstitutional and discriminatory practices demonstrates their attitude towards such discrimination in regard to employment decisions. Despite the Supreme Court's ultimate decision, Red Hat continued to implement its DEI policies that engage in the same or worse discriminatory practices as affirmative action. On several occasions, managers and executives at Red Hat, in comments to Mr. Wood and other employees, expressed their dismay at the lack of diversity in the workforce and their desire to achieve certain ratios in the workforce based on race and gender. Red Hat executives indicated that these DEI initiatives would influence certain hiring and employment decisions. Because of his religious, political, and personal views, Mr. Wood was vocal about his opposition to these discriminatory policies and continuously advocated for hiring based on merit and skill rather than other immutable characteristics. Several managers took issue with Mr. Wood's opinions and expressed their strong disagreement. Mr. Wood felt he was being targeted, marked, and labeled as an undesirable employee for voicing his opinions in opposition to Red Hat's DEI policies. Red Hat made express statements, both vocally and in writing at company events, that were derogatory towards white individuals and presented an anti-white agenda. Red Hat also remarked on the low number of women employed and expressed anti-male rhetoric. Red Hat made it clear that it was going to implement heightened DEI policies with the sole intent of increasing diversity. At a kickoff event in Texas, Red Hat announced its bold DEI goals. These goals included quotas. Red Hat sought to remake its workforce demographic, seeking to reach 30% women globally and 30% associates of color in the United States by 2028. One thing you cannot do is quotas. You can't say we're going to have a certain percentage of people with a certain skin color or a certain gender or a sexual preference. Even before the win against Harvard on affirmative action in the Supreme Court, that was not legal. Just 2 weeks after this announcement, Mr. Wood was informed on July 17, 2023, by his manager, Jason Corey, that his role was being eliminated, following several months of discriminatory treatment. Mr. Wood understood that he would be terminated from his position along with 21 other individuals. Upon information and belief, 21 of the total 22 individuals were white and 21 were male. Mr. Wood felt that his termination was a direct result of Red Hat's DEI policies and efforts to diversify the workforce, and therefore he was directly discriminated against because of his race, religion, and gender. Mr. Wood expressed this assumption to his superiors, informing them that he believed they were discriminating against him on these bases. Prior to his official termination, Red Hat continued to discriminate against Mr. Wood. For example, Mr. Wood applied for and, upon producing documented proof of an ongoing family health emergency, was granted leave under the Family Medical Leave Act on July 24, 2023, to take care of his ill wife. However, although his FMLA request was granted and Mr. Wood was entitled to 3 months of leave, Red Hat cut off his leave just 4 days later on July 28, 2023. To proceed with his termination, and his FMLA claim was officially closed on August 20th, 2023. At the same time, Mr. Wood's medical coverage was suspended, and he was forced to reinstate it at his own expense. Mr. Wood was officially terminated from Red Hat as of September 20th, 2023. Red Hat discriminated against him on the basis of his religious beliefs, race, color, and gender, as well as retaliated against him for voicing his opinions regarding Red Hat's discriminatory DEI policies. Defendant's stated reason was a pretext for racial and sex discrimination. Plaintiff was terminated, as demonstrated by Red Hat's admitted goals of altering the diversity quotas of employees, thereby targeting white employees as a direct result of his race. Furthermore, plaintiff was terminated, as demonstrated by Red Hat's admitted goals of increasing the number of female employees, thereby targeting male employees as a direct result of his sex. Plaintiff's complaints of discrimination and overall criticism of Red Hat's DEI initiatives a protected activity were a motivating and/or determinative factor in defendant's discriminatory treatment of plaintiff, including without limitation in connection with his termination. As a direct and proximate result of the discriminatory and retaliatory conduct of the defendant, plaintiff has in the past incurred and may in the future incur a loss of earnings and/or earning capacity, loss of benefits, pain and suffering, embarrassment, humiliation, loss of self-esteem, mental anguish, and loss of life's pleasures. Here's a good question. Is your employer really responsible for your pleasure in life? No, they're not, except when they do something that interferes with you being able to have a normal living existence. And this employer did, at least according to the plaintiff. Plaintiff is now suffering and will continue to suffer irreparable injury and monetary damages as a result of defendant's discriminatory acts unless and until this court grants the relief requested herein. Defendant acted with malice and/or reckless indifference to plaintiff's protected rights. The conduct of defendant Red Hat, as set forth above, was outrageous and warrants the imposition of punitive damages against defendant. Plaintiff suffered irreparable injury and monetary damages as a result of defendant's discriminatory acts. And now they go on to explain 4 causes of action. What legal rights do they really have to sue? Is there a law against what defendant Red Hat actually did? Yes, there are multiple laws against it. First cause of action, racial discrimination. Violation of Title VII of the Civil Rights Act of 1964. Plaintiff hereby incorporates by reference the allegations contained in the preceding paragraphs as if fully set forth herein. Title VII prohibits discrimination against any individual with respect to his compensation, terms, conditions, or privileges of employment because of such individual's race, color, religion, sex, or national origin. Defendant Red Hat's above described conduct and repeated acts of discrimination targeting plaintiff for termination on the basis of his race violates Title VII. The violations articulated in this complaint were done with malice and/or reckless indifference to plaintiff's protected rights and warrant an award of punitive damages. As a direct and proximate result of defendant's violation of Title VII, plaintiff has suffered the damages and losses set forth herein and has incurred attorney's fees and costs. The second cause of action, the second reason they have a right to sue. Gender discrimination, violation of Title VII of the Civil Rights Act of 1964. Plaintiff hereby incorporates by reference the allegations contained in the preceding paragraphs as if fully set forth herein. Title VII prohibits employment discrimination on the basis of sex. Red Hat's above described conduct of targeting plaintiff for termination on the basis of his sex and repeated acts of discrimination violates Title VII. The third cause of action, retaliation, violation of the Title VII of the Civil Rights Act of 1964. Title VII also prohibits retaliation against an employee for engaging in protected activity and opposing an unlawful practice that is prohibited by Title VII. Plaintiff engaged in protected employee activity by raising legitimate complaints to executives and employees at Red Hat concerning defendants' discriminatory DEI policies and practices. So you can't say, well, you're making too much noise about our illegal practices. We need to fire you now. No, that's not something you're allowed to do as an employer and not get sued. Plaintiff advocated on numerous occasions for merit-based hiring decisions rather than selecting or promoting individuals based on immutable characteristics such as race or sex. Red Hat's above described conduct of targeting plaintiff for termination for expressing his views on racially discriminatory company policies violates Title VII. By committing the foregoing acts of discrimination and retaliation against plaintiff, defendant has violated Title VII. As a result of raising these concerns, plaintiff was subject to punitive treatment in the form of denial of FMLA benefits and termination. Because if he's caring for his ill wife and all of a sudden they say, oh, no, we've got to fire you right now instead of letting you at least go through your legitimately earned leave, that is retaliation, at least in this case, but it just makes it worse for Red Hat. There's no excuse for that. There is a direct connection between the employee's protected activity and the defendant's discriminatory actions. And the fourth cause of action is racial discrimination. All persons within the jurisdiction of the United States shall have the same right in every state and territory to make and enforce contracts, to sue, be parties, give evidence, and to the full and equal benefit of all laws and proceedings for the security of persons and property as is enjoyed by white citizens, and shall be subject to like punishment, pains, penalties, taxes, licenses, and exactions of every kind, and to no other. Section 1981 of 42 U.S.C. applies to employment contracts. In its quest to achieve its DEI goals, Red Hat intentionally discriminated against Mr. Wood on the basis of his race. Mr. Wood's race, which is white, was a but-for reason or determinative factor in Red Hat's decision to terminate plaintiff from his position. So they would not have terminated him but for the fact that his race is white. That's his allegation here, and it does seem pretty well backed up. As demonstrated by Red Hat's DEI policies and the disproportionate number of white employees that Red Hat elected to terminate, Red Hat clearly acted with the intent to discriminate on the basis of race. Red Hat intentionally discriminated against Mr. Wood on the basis of his race, but for Red Hat's racial discrimination against Mr. Wood, he would not have been terminated. And in a fifth cause of action, which I first just saw now, I thought there were only 4, but there are 5. Violation of Family Medical Leave Act. The FMLA makes it unlawful for an employer to interfere with, restrain, or deny the exercise or attempt to exercise any right provided by the FMLA. Mr. Wood was eligible for FMLA benefits and, at all relevant times, was an eligible employee as defined by the Act. Red Hat is a covered employer under the FMLA. A covered employer would mean they're an employer that has to comply with the FMLA. The FMLA allows eligible employees of covered employers to take a total of 12 weeks of leave during any 12-month period to care for a spouse, son, daughter, or parent who has a serious health condition. Mr. Wood's spouse had a serious health condition as defined by the FMLA. Mr. Wood gave Red Hat reasonable notice of his need for leave. Defendant Red Hat interfered with Mr. Wood's right to take FMLA leave by refusing to allow Mr. Wood to receive all of the FMLA benefits to which he was entitled, and then terminated Mr. Wood. Mr. Wood was thereby denied benefits and rights to which he was entitled in violation of FMLA and has suffered damages as a result. And at the bottom of all this is what the plaintiff, Mr. Wood, wants from Red Hat. First, a declaration that defendant discriminated against plaintiff in violation of Title VII. Also, a declaration that defendant discriminated against plaintiff in violation of USC 42, Section 1981. A declaration that defendant violated the Family Medical Leave Act. Enjoin and permanently restrain the violations alleged herein. Award compensatory damages to make plaintiff whole for all lost earnings, earning capacity, and benefits which plaintiff has suffered as a result of defendant's improper and discriminatory conduct. And when we say make whole, we mean make up for the missing money. Award compensatory damages to plaintiff for past pain and suffering, emotional distress, mental anguish, humiliation, and loss of life's pleasures, which plaintiff has suffered as a result of defendant's improper and discriminatory conduct. Award compensatory and punitive damages to plaintiff under Title VII. Award compensatory and punitive damages to plaintiff under USC 42, Section 1981. And order that plaintiff be awarded other such damages as are appropriate pursuant to applicable federal or state law. And order that defendant pays plaintiff's costs associated with bringing this lawsuit, including his reasonable attorney's fees and costs. And a grant of any such further relief as the court deems necessary and proper in the public interest. The compensatory damages are for monies that he directly lost. The punitive damages are punishment to the plaintiff for taking such completely reckless and inappropriate actions. Many employees, whether they're white or Asian, or male but they're not the right skin color, or whatever the agenda is from diversity, equity, and inclusion, have suffered damages as a result of illegal activities by their employers. We have not seen enough lawsuits about this. We are now seeing more lawsuits about this. It's clear from the story from the plaintiff, some of his rights seem to have been violated. He's got 5 causes of action, and even if he doesn't win on every cause of action, he's probably going to win on at least a couple of them. I will continue to follow this story and let you know how it turns out. Hopefully this is the first that we see of many lawsuits like this where employees get their rights respected. Let me know what you think of all this in the comments below. Always love to see your ideas. Please be sure you are subscribed to the channel. Click the bell for notifications, give me a thumbs up, and I'll see you again soon with another story. And if I don't see you, I will miss you.